Hello and welcome to the Sobirovs Law Firm live show. My name is Rahmat Sobirov, managing lawyer of the firm. I'm connecting with you live from Toronto, Canada. And every Wednesday at 10:30 a.m., we are here to answer your questions and present an interesting topic. Today, we will be discussing low wage and high wage LMIA. So don't go far away. Let's get started.
Just a quick reminder before we start. Please note that whatever you hear in these live sessions or any content you see on social media by Sobirovs Law Firm is general information only and not legal advice. While we may use certain real-life scenarios or legal cases for learning purposes, it is important to remember that this does not constitute a legal opinion. For personalized legal advice, please consult with your lawyer or hire a Canadian immigration lawyer. Now, let's get back to our show.
Before we delve into the conversation of low wage and high wage LMIA, I want to bring up two pieces of news that might be relevant to you that happened last week. Let's get those pieces. Number one is, if you remember, we did a piece on H-1B visa holders in the US and the new pathway for those in the US that they can come to Canada. 10,000 application cap has been reached within 48 hours. So it was opened on July 16th, and within 2 days, that cap has been reached. So you can see how popular is Canada among tech workers, but don't get discouraged. There are many other ways for you to come to Canada if you are a tech specialist or a person that Canada needs. So this was just a blip in the system, let's say, but there are many other pathways. If you decide to come to Canada, contact us for more detail. The second piece is coming from Ontario. The government of Ontario decided to make it illegal, starting from next year, to hire temporary foreign workers from unlicensed agencies. So it will be a licensed activity, and starting next year, it will be mandatory to hire foreign workers from licensed recruiters. So stay tuned. We will update you on those pieces as we go forward. Now we will delve into our presentation.
To stay updated on all things related to Canadian business immigration, check us out on social media. Follow us on Instagram, TikTok, LinkedIn, Facebook, and Twitter for the latest news and updates. Subscribe to our YouTube channel and click the notification bell to stay informed about the most recent immigration news, interviews with top immigration specialists, and our weekly live shows. Visit our website at www.sobirovs.com for more information or to book a consultation with our team of experts.
So today's topic is difference between high wage and low wage LMIAs. But don't forget that after my quick presentation, I want to make it short. I will get to your questions. You can start typing your questions. You can tell us where you're joining us from and how Canada is interesting to you. Okay, so we will focus on major differences only without going into deep legal analysis, because this topic is quite legal and technical. I want to make it available, the concepts available for the general public. Most probably the LMIA process can be interesting to both the hiring party, the Canadian employer, and those who are seeking employment in Canada. There will be no discussion of LMIA supporting your PR, although these both categories, low wage and high wage, can support your PR objectives too. So let's get into the basics. So when I say LMIA, I mean Labor Market Impact Assessment issued by ESDC. Basically, you can understand it as a permission for Canadian employer to hire a foreign worker. Understand it as simple as like a permission, LMIA. Low wage positions are those positions that get below the provincial and territorial median wage. High wage positions are those who are getting above the median wage. So low wage, high wage, the biggest distinction is the pay that they receive. And many industries have both low wage and high wage positions, okay? PR, when I say PR, I either mean permanent residence or permanent resident who has a status. The LMIA process for both low and high wage is relatively similar with some exceptions, of course. in terms of, similar in terms of taking the steps to get an LMIA for low or high wage positions. So compliance applies to both. So it's not only that you hire, you should also comply with certain requirements after you hire for low wage or high wage positions. The prevailing wage, many people, they get confused between prevailing wage and median wage. The prevailing wage is the median hourly wage depending on the region and occupation. So as you can see, as of May 31st, 2023, each province has its own prevailing wage. So high wage LMIAs, for example, LMIA workers must be paid salary equal to or above this prevailing wage. There are certain exceptions, certain digressions from this general rule based on the type of activity and the location of that activity, but the general rule that doesn't change much. And if you are hiring for ski and snowboard instructors in the region of Cold Lake, and medical graduates in Quebec, and fee for service physicians, you need to delve more into how they are paid and how you achieve the high wage classification or low wage classification. Okay, this is more about, so there are different types of LMIA applications. And you can see here on this table, as of June 2023, the processing time is a bit different for each categories or types of applications. The longest it takes for permanent residents to support the LMIA supports your permanent residency, and it takes 54 days as we speak now, but then followed by a low wage stream and so on. The fastest we can see is a seasonal agricultural worker program because it addresses the seasonality. It's very sensitive to time. So government process that kind of application faster. Okay, in terms of basic steps, in general, to hire a foreign worker, most of the time, Canadian employers need to obtain an LMIA. Okay, there are exceptions, but this is a general rule. When you hire a foreign worker, don't forget, as an employer, you will pay Canadian wages. That's that's relevant to compliance. So you cannot say, you're a foreign worker, I will pay you less than what I would pay for a Canadian, right? So job offer can support the work permit application of the worker and the PR application of the worker. So in terms of philosophy and principles, government likes when you support the foreign workers' PR. But as I said today, we don't have enough time to delve into the PR aspect of LMIA. So also in terms of steps, make sure that the LMIA-based route is the best route for you, because there are many other routes to bring foreign workers. So first things you need to do as a Canadian employer is to make sure that LMIA is the best way to go. So make sure that. As an employer, also make sure that you need a foreign worker as opposed to Canadian worker, because the whole LMIA philosophy is geared towards encouraging you to hire locally. And of course, there are certain exceptions. Now, the main differences. As I said, I will focus only on the main differences of these low wage and high wage programs. In terms of experience, years of experience of the candidates, low wage positions usually require 1 year experience, but as an exception, it can require up to 3 years experience, okay? Primary agriculture positions can have both streams, the high wage stream and low wage streams, in terms of positions. If the job is a high wage position within agriculture sector, one advertisement platform that you use to hire and advertise the position, one platform should be national in scope. So it should address across Canada. Such platforms are like Job Bank and other platforms where you should advertise your open position. If the job is a low wage position, now see the difference, each advertisement platform where you advertise the position must target an unrepresented group, such as newcomers, Aboriginal candidates, and so on. So underrepresented group should be your target in terms of low wage positions. You need to advertise those and give opportunities to those members of those groups. Senior positions or managerial and supervisory positions usually require 3 to 5 years of experience. Senior managers can require 5+ years in managerial experience. So you need to identify this needs to be followed when you are advertising and preparing your ads and then applications. High wage LMIA, the philosophy here is more about transmitting the knowledge of the foreign worker who is senior, right? Because he's high wage, he's more experienced or she's more experienced. So the main philosophy is, okay, you bring a foreign worker, but he or she needs to transmit the knowledge, the expertise to local Canadians to create more opportunities for the Canadians. So that's the whole idea of high wage LMIAs. Low wage LMIAs are more about addressing the labor shortage, the seasonal agricultural program, agriculture stream, and so on. They address the immediate need for talent and labor. So both can support PR, but realistically, in our experience, it is the high wage position usually really supports your PR, because the occupation code 0, A, and B should be applicable to that position. And then it can add 50 points or sometimes 200 points, depending on the position, and fully supports the PR of the foreign worker. All right, now we talked about common things and a little bit of differences. Now let's focus on low wage. If you are hiring for a low wage position, you need to take into account these elements. First, the transportation from the country of origin of the worker to Canada and back is covered by the employer. You should take care of that. If the worker comes to Canada and then switches the employee switches from one employer to another with another LMIA, the new employer will be responsible for transportation costs. So you need to see that there are dynamics. When you bring a foreign worker, the foreign worker is not chained to your operations, right? He or she can change, but then again, the new employer will take over the transportation costs. The transportation expenses should not be recovered from the foreign worker. It's illegal and it's subject to compliance. Second element for low wage positions is because they are the nature of those positions are more low skill and requires distant communities, sometimes the agricultural community, rural communities, the accommodation should be taken care of. Employers must ensure a proper accommodation and affordable accommodation is available for the foreign workers. Sometimes on agricultural sector, people organize mobile homes and so on, so that they take care of that. The healthcare is a major issue, especially during the pandemic. That was, the highlight of the problems. When you bring a foreign worker, he or she does not access to provincial healthcare system immediately. There's a certain period of time that after which the provincial or territorial healthcare is available for a foreign worker. In the meantime, you need to take care of that aspect too. The healthcare, the employer must provide coverage during that period when the worker cannot benefit from available provincial healthcare coverages. LMIA applications for low wage positions must include employment agreement. There's a sample employment agreement that you can find online, but it must be a part of your LMIA application. So this is very specific to low wage positions. Now let's tackle the high wage position and some misconceptions about high wage LMIAs. Many people think incorrectly that it's too restrictive. It's not restrictive, it's quite flexible. Yes, it is connected to one employer, but there is a flexibility to move around from one employer to another. And it's not limited to only a few countries. All nationalities of all countries can potentially apply for high wage LMIA work permits. Extremely complicated is another misconception about high wage LMIA. With the right guidance, with the right preparation, it can be done very easily. And the good side is once you do it successfully the first time, the next and the subsequent time it's going to be very smooth. So the truth about the high wage LMIA is that it can be a great source, a reliable source for Canadian employers to get international talent into their operations. It's an excellent opportunity to retain those talented people in your organization, in your company, by supporting their permanent resident. Imagine when you bring a high wage LMIA worker, he or she is attached to you for up to 3 years on a work permit status. Then if you support their PR ambitions, that means that the PR also processed longer, and usually the employer can retain that talent for at least 3 to 5 years, because PR aspect is the one that may be another encouragement to stay with that employer. So it's easier to hire additional LMIA workers after the first one. So as I said, once you do things right in the first application, the other applications that come after that are very manageable, very easy to do. Okay, high wage LMIA has a very specific element. Now it's what distinctive elements that the high wage LMIA has is a transition plan. As I mentioned earlier, it is about transmitting the knowledge of the high wage LMIA worker to your Canadian staff members, right? The plan is mandatory. The transition plan must be included in your application. And it describes various activities agreed by the employer to recruit, retain, and train Canadian citizens and permanent residents in the subject positions. Okay, so again, the logic is to transmit the knowledge and expertise. The aim here is to reduce your reliance on foreign workers, because one foreign worker high wage LMIA can train, let's say, 5 people, and you are less reliant in the next time for the same position, for the same job. There are distinct activities that must be mentioned in your plan. 3 distinct activities should relate to recruiting, retaining, and training Canadians, and one distinct activity should be relevant to the work that you do with an organization of serving underrepresented groups, Aboriginal population, newcomers, women at work, and so on. So there are underrepresented groups, or instead of these activities, you can support the workers' permanent residency. Note here, government encourages you in a way to support foreign workers' PR ambitions. Okay, it is enforceable and it's mandatory and enforceable. It's subject to compliance. If you have previously submitted transition plan for other positions, for the same position, for the same location, you will have to report what have you done with respect to the old plan before submitting the new plan. So government will look at that. So, and it's subject to compliance reviews from time to time. As always, there are certain exceptions, but those exceptions are minor in comparison to the general rule of transition plan for high wage LMIAs. All right, this is the end of my presentation. Now we will get to your questions. How Sobirovs can help you and your team, your Canadian operations, to get talent, whether it's low wage or high wage. We can build a long-term strategy. We will implement that strategy with you, and we will tweak it. We will revise it accordingly, because laws change, things change, and we change with them too. We specialize in comprehensive business immigration strategies and solutions. So if you have any questions as a Canadian employer looking to hire foreign workers, if you want an honest opinion of experienced lawyers, book a meeting with us. And don't worry about the payment. If you don't see any value in that meeting, after you have the meeting, we will refund the meeting cost. And make sure that you follow our social media handles. And now we will get to your questions. Let me bring it to the screen.
To stay updated on all things related to Canadian business immigration, check us out on social media. Follow us on Instagram, TikTok, LinkedIn, Facebook, and Twitter for the latest news and updates. Subscribe to our YouTube channel and click the notification bell to stay informed about the most recent immigration news, interviews with top immigration specialists, and our weekly live shows. Visit our website at www.sobirovs.com for more information or to book a consultation with our team of experts.
Okay, it's time for your questions. Thank you for active participation. We have questions from Negar Mozaffari. And she's asking, can I, as an experienced carpenter, apply for C11? If yes, what would be my position in the startup company in Canada? Can I still apply for executive manager, and what would be the path for PR? That's a very loaded question, Negar. It requires a thorough analysis of that candidate, but in general, carpenters can open a business, create more jobs in Canada, and become a business owner. By becoming a business owner, they get, of course, the work permit, as you know. Then they get ready for PR options. And during that time on a work permit, they will be paying themselves the salary from their company and getting ready for PR. If they get IELTS 6, the language test, then the company that they created may offer a high executive position as a manager, in the senior management position of the company. Yes, then there might be a possibility to move with PR options. The carpenters can open a carpenter related business, which is one of the most in-demand positions in Canada, and hire Canadians, create job for Canadians. C11 could be suitable for such a candidate. Second is the question comes from Mayon Wijesinghe. I hope I'm pronouncing that name correctly. Is this only talking about IT skills jobs? No, we are talking about different jobs, low wage jobs and high wage jobs. IT skills related jobs mostly fit under high wage because they are paid higher than the median provincial rate. And he says that he's from Sri Lanka. Greetings to Sri Lanka. There are many applications from Sri Lanka to Canada. That's great to hear. Next would be a question from James. He says, what do you suggest should the wage be for a senior executive category 00, NOC 00 in Ontario? Does the senior executive need to be paid monthly, or can it be deferred for dividends? No, dividends are not counted. So we didn't go into the details of compensation aspects, but it should be a payroll, regular payment of salary. In Ontario, don't quote me on that, but as far as I remember, the NOC 00 positions require $58 per hour. But please double check. Things change from month to month because Statistics Canada makes some inputs. The median wage may change slightly, $3 there, $5 down or something. So in our practice, as far as I remember, in Ontario, it was around $58 per hour. Okay. Next, yeah, I can greet all other who are participating. Bhupinder Nanda, hello there. And S. Rao question is, the H-1B program that you talked about at the outset, was it a one-time program or will it reopen again in 2023? Excellent question, Rao. Thank you very much. I hope it will become more regular or even permanent program. And again, don't be discouraged. It was a one-time, I would call it opportunistic attempt by Canada to lure H-1B visa holders from the US. There are other permanent programs for H-1B category workers to come to Canada. Don't just rely on that 10,000 capped program look into more sustainable, more permanent programs. There are some programs. You can check our website at tech immigration section of our website at sobirovs.com. We dedicated a specific tech immigration section. We are actually popularizing the word tech immigration in the industry, and we are happy to report that people started to use the combination tech immigration. So go check at sobirovs.com, tech immigration section. There are more reliable, more permanent programs. And I hope, as you mentioned, it will reopen again soon. I hope so. But as far as we know now, it was a one-time opportunity as we speak for H-1B visa holders. But there are more permanent programs. Now, and another question is from Sam. Is IELTS mandatory for me as a CEO for a consultancy business through C11, even if I lived in a native English-speaking country? It's not mandatory, but if you have, that proves that you are a best candidate to function in an English-speaking society like Canada. It's not mandatory, okay? We have done successful applications for C11s for our clients without English language test. But of course, we discussed the language capacity and capabilities of the candidate in our legal submission. We addressed that concern because sometimes visa officers look at that candidate and say, by the way, this person is not a native speaker. How does he or she run a reliable, a genuine business in Canada? What's the feasibility of that? So they address that question, and we present that our arguments based on the candidate's qualifications. And if you lived in a native English-speaking country for a substantial amount of time, I think it's not a hard thing to prove that your English level is sufficient to run a business in Canada. Okay. Now, next question is from the account name called Ratings and Reviews. Let me read that long question. As a startup visa entrepreneur on a work permit, is it possible to take a job on a B2B arrangement outside of province in which my work permit is restricted? How will it affect my PR application? Oh, that's a good question, and of course, again, requires a thorough analysis of your situation. But recently, the Minister of Immigration, Sean Fraser, announced that the startup visa permanent resident applicants can get open work permits, but you are already with a restricted work permit, and B2B arrangements through your startup could be an opportunity to explore. You cannot work, because it's restricted, you cannot work for somebody else on a payroll or something. If you do business to business through your startup and deliver services to someone outside of your province, probably that's a possibility. But again, look into that and consult a lawyer and make sure that you're compliant with your work permit limitations. And again, maybe it's I haven't heard anything from the government yet. Now that the startup visa PR applicants can get open work permits, three-year open work permit, maybe it's worth exploring if you can switch your restricted work permit to an open work permit. That's just my creative side thinking. If it is possible and you may communicate that intention to the government, perhaps there's a way to switch from the restricted work permit to open work permit, because the gateway, the floodgates has been opened by the government recently, right? Okay. Now another follow-up question from James. Let's take that question. Regarding your answer about around $58 per hour for senior executives in Ontario, does it have to be that high even for a new business trying to establish itself? If it's knock double zero, yes, the age of the company doesn't really matter. The knock double zero positions deserve basically certain amount of payment. So you got to go with that. And perhaps, and if not, if Ontario wages are too high, perhaps relocating the business to another location, which is more feasible, like in terms of payment, could be an alternative way of resolving that issue. Yes, it doesn't depend on the age of the business. When you make a knock 00 job offer, you need to prove that you can pay the salary for that knock 00, and the company is financially strong enough to pay that salary, right? It doesn't really matter the age of the company. If you injected a lot of sufficient money to the new company, that company can pay the salary, right? So that's the argument you need to make. If by giving a knock 00 job offer, you want to increase the point of the candidate by 200 points, CRS points. All right. And then another follow-up, let's take it from James, is a high wage a determining factor when considered for knock 00 position? Yes, it is a determining factor, because knock 00s are unique, in the sense that they require a lot of education, a lot of experience in the position, and so on. So these are not the positions that for which you can pay $20 per hour, right? These are positions that require different kind of payments. The next question from S. Rao. The follow-up, I think this is a follow-up question. Are there programs realistically available for cruise ship workers who would like to be in hospitality sector, who want to move to Canada on a work permit? Well, from top of my head, there are many hospitality industry players like hotels and so on. They're hiring in Canada. They do LMIAs. So you may consider those. Hotels are desperately hiring these days because during the pandemic, many people left the industry and they're not coming back. So think about that. Contact the hotel chain's direct positions announcements on jobbank.gc.ca. Jobbank is your friend. Go and search hospitality positions. It is realistic to come on a work permit for hospitality industry. Yes. Okay. So James also did a follow-up question. Let's bring it up. Regarding your comment about switching a closed work permit to an open one, does it apply to C11, a closed work permit? No, C11 is the one that is attached to the company. I was talking about the startup visa applicant because you said it was the startup. The question was about the candidate who came through startup visa program work permit option, right? So another question from ratings and reviews. Let's bring that up. Since ratings and reviews is asking the question, since the minister didn't specify the start date for issuing open work permits for startup visa applicants already in the pipeline, do you know if that has commenced? Yeah. At the moment, if you have already applied for PR under startup visa, the door is open. You can apply for the open work permit now. Yes, those in the pipeline, there wasn't very clear distinction whether it's a new applicants for startup visa PR or it was existing in the pipeline. The pipeline is about 17 to 18,000 applications right now, as far as I heard. I think they cannot really discriminate between old and new. I think those who applied for PR under startup visa program can now apply for an open work permit to come to Canada earlier, start working on their startup, and also work for somebody else to make the income, right? Because usually the government has recognized, and we as an industry experts have been telling the government that the attachment of a worker to the startup doesn't allow them to earn the living, because startups usually at their initial stage, they cannot pay salaries, right? It's basically volunteer activity. Usually startups are cash negative usually. So that's the recognition by the government that yes, those startup visa applicants can come to Canada, work on their startup while also working with an open work permit to other entities without any restrictions. Okay, and finally, final question from ratings and reviews. Let's bring it up. The question is, finally, for an SUV work permit that was approved in before the change, but the applicant arrives in Canada in August or September, will they be issued the new work permit with the closed one? That's a great question. Government hasn't clarified that. If it's not clearly forbidden, probably it is possible to ask for open work permits. If the arrival is in August and September at the border, try to explain to CBSA officer that yes, we applied to work permit before the announcement by immigration minister. Have a submission letter, basically. Give it to them. Let them read it. Probably try to persuade on the spot to get open work permit. I would try it. It's worth trying. Maybe they will say no, but I would try that position, that argument at the border. Okay. All right. I think we don't want to take too much of your time. It's more than 30 minutes now. Let's take the last question from James and then call it a day today. For NOC 00 high wage level, does the city matter or is it applicable to the province only? You should go to Job Bank and see the specific locations too. Okay, sometimes there's a variation of $1 or $2, $3 from Toronto to, let's say, to Timmins, Ontario, right? So, or Thunder Bay, Ontario. There is a difference. Yes, depends on the location, depends on the position. So both needs to be taken into account. All right. Okay. Don't forget to follow and like this video if it was useful for you. Join us every Wednesday at 10:30 a.m. Toronto time for live shows and Q&A sessions. Hope to see you in Canada soon. Thank you very much for your participation. See you.